Support for this podcast is provided by Portugal Pathways. Portugal Pathways are experts in navigating Portugal's Golden Visa Residency by Investment program. With an investment of €500,000 and a required stay of just 7 days per year in Portugal, you and your qualifying family can gain freedom of movement across 29 European countries without automatically becoming tax residents in Portugal, allowing many internationally minded families to retain their existing tax base. Portugal Pathways supports international families and their advisors in understanding the Golden Visa process, the range of investment options, and the flexibility this program offers. Contact Portugal Pathways at portugalpathways.io. Again, that's portugalpathways.io.
Welcome to Tax Notes Talk, a podcast from Tax Notes, the leading source of tax news, information, and analysis.
Welcome to the podcast. I'm David Stewart, Editor-in-Chief of Tax Notes Today International. This week, may it please the pod. Patrick Urda began his term as Chief Judge of the U.S. Tax Court in June of 2025. He's settling into leading a court that has had to consider the impacts of several notable tax and tax-adjacent Supreme Court cases, as well as the changes at the IRS. Now, if you're interested in hearing a bit from Chief Judge Urda's predecessor, Kathleen Kerrigan, you can find a link to that interview in the show notes. But here to talk more about his interview with Chief Judge Urda is Tax Notes senior legal reporter Nathan Richman. Nate, welcome back to the podcast.
Always a pleasure.
So could you give us a bit of background on Chief Judge Urda?
He was appointed to the tax court in 2018 by President Trump. Before that, he worked at the Justice Department Tax Division on appeals.
And what sort of issues did you talk about?
We discussed his background, litigation trends in the court, and other court updates.
All right, let's go to that interview.
Well, welcome to the podcast. Thanks for joining us.
Thanks so much for having me. I'm excited to be here.
We're excited to have you. Let's start out with how you came to the tax court and what got you started in tax in the first place.
Sure. I had kind of an unconventional path to tax more broadly. So when I came out of law school, I was more in the general commercial litigation mode, and that wasn't for any particular reason. My dad was a solo practitioner back in South Bend, Indiana, and he did lots of ERISA work, and then that also bleeds into trust and estate. So a lot of tax components, but more on the planning side. And when I was coming out of law school, even though I enjoyed my tax classes, I never really thought that was a path for me because the professors of tax were just so outstandingly brilliant. I've got a classmate now who's a professor up at Harvard, Tom Brennan. Now, that is a guy who you feel like, that is a tax professor. That is a tax practitioner. He can do this. But Pat Urda, general commercial litigation feels about right. And I wasn't coming off of a background of accountancy or anything more traditional. I was a classics major. So when I got out of law school, I started at a private firm and just did commercial litigation, and that didn't quite click in the way that I was hoping. It didn't kind of get me out of bed in the morning. But there were some experiences that really did resonate with me, and those experiences had to do with kind of appellate arguments. And I had the opportunity to go back to South Bend, where I'm from, and clerk for a Seventh Circuit judge, and that kind of deepened the connection with the appellate world. And just so happened that when I was looking for a job after the clerkship, there was a place at DOJ tax in the appellate section that was open. So I threw my hat in the ring for that, and Gil Rothenberg and Dave Pincus and Tom Clark, who were the leadership of the section, brought me on, and it was just the most revelatory and most wonderful time for a young lawyer, both because they were exceptional advocates. Everyone there from the reviewers, basically the section was structured so you'd have the line attorneys, and then you'd have reviewers who are basically the editors of the briefs. But they were also subject matter experts, so you'd really get to know this by working with Bruce or Richard or Terry or John. You'd get to know particular subjects very well. But more than anything else, you have amazing people like Francesco Golini and Judith Hagley and Nate Pollack and Andy Weiner and Melissa Briggs, all these great folks. you spend enough time, you're just inundated with people who have a true passion for tax. And it's contagious. You can't not feel that. And, kind of looking back, whether it's by osmosis with Dad in his own practice, which was more on the planning side, perhaps my mom, who was a stats professor. So maybe some math did, sink in there somewhere. I just don't know where. But then working with such amazing colleagues and just seeing, I'd be remiss if I didn't also mention Diana Erbsen and Caroline Cirolo. Those are the two most passionate tax lawyers you'll ever meet. They love it. And, like so much in life, I think when you're around people who love a subject and you spend enough time with it, that's really that deepens your appreciation, and eventually you kind of catch it too. So that's what really brought me to tax law more broadly.
So what has been your favorite part of being a tax court judge, and is it something you had to give up when being elected to be chief judge?
Well, I think for me, the absolute favorite part is the people, are the people. And I have and I haven't. And I'm going to break that down a little bit because I fundamentally believe that the job of a public servant is to serve the public. We're in the customer service business as judges, and we are there to try to give people answers so they can go about their lives. That has to do with the lawyers, but it also has to do with the people who have tax disputes with the government. So our focus should be on them, and that's what I really loved. Going out to a regular trial session, giving people their day in court, letting them have their opportunity to explain to me. Sometimes they do a good job. Sometimes they would do a less good job. Sometimes they would need a lawyer to help, either represented or a pro bono person. Obviously, low-income taxpayer clinics play a huge role in our work. So, but really give me what the problem is from their perspective, and then allow government to introduce their evidence and let me see what Congress says about this situation. So that's the special thrill about being a judge, being able to be there to help in that process, to listen to people, and then try to decide, okay, I've tried to understand what was going on as much as possible. Now let's see what the law dictates here. But another part of that are just the people that I see on a day-to-day basis. And those are just like any workplace where you're, all chambers are a small family. So we have Janet right now we have my clerk, Corey Kaiser, and my former clerk, Matt Marcelino, unfortunately had to leave us. But, those are the people that you see most proximately, and that's really your work family. And then you broaden out, and then you see like all sorts of people just in the court who do so much important work to make sure that tax resolutions are possible and that we're able to complete the mission of the court just as well as possible. And so obviously Charles Jeanne, our clerk of court, but he has an amazing team top to bottom that really does the business of the court. So when you ask, did you have to give up something you truly loved to be chief judge? As chief judge, you kind of step away from as many trial sessions. Exactly. So I have stepped away or stepped back, not totally away. I still like to do at least one trial session of the regular sort per term. And then there are special sessions. I had one last week in Miami. It was a real labor of love to be out of beautiful DC weather to go down to Miami for a couple days. But, that I've done the work for, so can't really pawn off on somebody else. But so I'm missing those people interactions. But on the other hand, they've been replaced with stronger interactions on the administrative side of just knowing the people who really day in, day out keep the court in business. And I think that as judges, we appreciate that on a certain intellectual level. But as a chief judge, whether it would be Marvel or Foley or Kerrigan or myself or Judge Cohen, of course, I think that really comes home when you see these people and so see how hard they work and how dedicated they are to the tax court mission.
So less interactions with taxpayers, more interactions with the court staff.
You said it so quickly and so well, and it took me a million minutes to get there.
Sorry.
No, you're the best. This is why you're doing what you're doing.
So tax court judges, they see some of these great big billion-dollar tax disputes, but they also see everything else. What is the most entertaining or weirdest case that you've tried or decided?
Oh, I would have to go with a case involving mini donkeys. So I think that this is a beautiful microcosm. So it was a case a few years ago in New York, right before the pandemic, and it was really about a father and a daughter. And so the father was a very wealthy guy, and he had a farm in New Jersey and bought some mini donkeys for the farm. And I think that anyone who's been in the tax world long enough probably would have a gut reaction, what's going on there, and whether it was a business or whether it was personal pleasure. Well, we get up to trial, and he takes the stand. And he takes the stand for the better part of 2 days to talk about what he did and why he did it. And a lot of it really, he had tons of documentation of the work that he did. And because he was particularly blessed in terms of finances, he was able to get some excellent experts to help him set up this mini donkey operation that had not done well. But he went through all of this, all of the things that one would do if they were trying to turn a buck. And I remember him just looking at me, and that's the nice thing about tax court. It's just you as the finder of facts, like evaluating the witness. And he turned to me at one point in time and said, "Listen, you know how much I make. I'm fighting for $10,000, $15,000, whatever it was. And the reason is because my daughter. My daughter does not accept charity from me. She likes to live a very close to the earth lifestyle. She and her kids, she has a dog grooming business. And one of my friends said, given your daughter's interests, this would be a beautiful business if you can get the genetics right. And this would be something that could supplement her income in a way that she would enjoy it, and you could know that you set up your daughter." And, when I heard him explain and kind of walk through everything that he did, it was pretty convincing in terms of his testimony that this was something, even though on its face it looked pretty weird. Here's a, millionaire, billionaire who's playing around with mini donkeys. But then you understand what he did, why he did it, and then you go to the law, of course, and go to his documentation and say, yeah, he didn't turn a profit, but based on what he had done up to that point in time, that passes the tests. And so, that it was such a bizarre case, especially because he capped off by saying, the thing is, I hate these mini donkeys. I absolutely detest them. They're ugly, they're smelly, they're all over the farm. And if it doesn't work in the next couple of years, we're out of this business. But I had to give this a shot because I think it would help my daughter, and that's what I care about. I remember him saying, I care about two things: my family and money. And in that moment, all I could think was, yes, you do, sir. You have convinced me of those two things. And I have to give credit to the government as well, because it was an interesting case. And the government did a very able job. And the true button on the case was, in closing arguments, the government attorney went through the factors of hobby loss and then ended with, "And Judge, I don't think that Mr. Petitioner was credible." And, you see this petitioner, master of the universe type, getting red in the face and starting to stand up to talk to his lawyer. And he said, "Because how could someone not love this mini donkey?" And he held up a picture of the mini donkey. And everyone just burst into laughter. So It was a very well litigated case by the lawyers, and it was also kind of a funny case, but it was a funny case that gave insights into, sometimes people do things that we don't understand at first blush, and what we really need to do is get the information as much as possible to decide whether it's appropriate or not under the laws that Congress has passed.
You got to love when good craftsmanship meets good facts.
Oh yeah, no, that's what you're waiting for. I mean, and it can come in unusual places, and it can come with unusual litigants. I mean, I remember one of the best pro se people was a steam fitter out in Spokane, Washington, and I mean, he was a foreman, so he had some supervisory skills. He had some background in leading a team, but man, oh man, was he just a natural born organized guy, and very logical in the way that he presented everything. And he was a very, very impressive litigant. So you just never know who you're going to get when you step on the bench.
Speaking of interesting litigation, there have been a few notable cases coming out of the Supreme Court on tax and tax-adjacent issues in the last couple of years, some of which have addressed issues that many in the tax community had thought well settled. Among Beckler, Zook, Moore, Loper, Bright, and Jarchese, which has had the biggest impact on the cases currently before the tax court?
Well, I would say that each of them have had significant impacts in their own way. And that's the job of the tax court. Our job is to look at what the Supreme Court has given us in instructions and always be responsive to what we see, try to apply it just as well as we can, whether it's, Loper Bright. Obviously, we've had a number of decisions over the last couple of years where we've started to integrate that framework. But being a trial court, we're always in the position of keeping one eye on the principles articulated by the Supreme Court and also looking at developments in the circuit courts. So what did the 11th Circuit say about Loper Bright, or what did the 9th Circuit say about Loper Bright, depending on where our case lies, and then trying to bring ourselves into line with both the Supreme Court and what we're seeing out of the circuit that would eventually have jurisdiction over the appeal in a particular case. So, all of them are huge cases, and as you know, they're bubbling through the system. And, in some of them, like Jarchese, we've had the Silver Moss case, or Hirsch Birdman. I know there was a petition filed recently in the Supreme Court on that one. So, we are in the position of kind of bystanders in some ways, but also part of the conversation, because we are given the ingredients. We try to use those ingredients, and then once our work is done in each of those situations, we have to wait to see what the circuits do with it, and then what the Supreme Court ultimately does if the issue is nuanced enough that they want to take another whack at it.
And you have the odd in our normal court structure geographic remit of covering the whole country when some of the circuits you go to don't, and the other trial courts, some don't.
Oh, it's one of the really interesting parts of the job, because you have to be a circuit watcher, even if your case isn't going to that circuit necessarily, because, I think circuits are very hesitant to go into split with each other. So you want to know what's happening in the circuit in front of you, but you also want to know how is this developing throughout circuits, and how might my circuit think about this? And these are all important considerations. Obviously, the tax court has the additional overlay of we follow our own precedent, which is unusual in a trial court. So you've got to look at tax court precedent, kind of figure out what's happening in the circuits, and think about, and no one really has talked about this new Supreme Court case, and put that together. So that's why I'm hesitant to say, oh, this case or that case has really been the most influential, because all of them are influential. And when something like any of those cases come down, we really have to go through our paces to make sure that we're getting the understanding of the Supreme Court as well as we can, and then trying to apply it in the tax court context as much as we can.
Is there a number of circuits coming down on the side of a particular issue that will cause you to start rethinking even a long line of cases? The jurisdictionality, the circuits are starting to look like they're leaning pretty heavily without any sort of a split, but it is a split with you.
Well, I think that it's one of those things where there's no set number, but of course the court has the court conference procedures. And so sometimes we will revisit issues. I think that Judge Cohen and Judge Halpern have both articulated in the past in written articles some of the considerations that chief judges often use for sending cases to conference. And one of those is whether a circuit has reversed us or opined on one of our opinions in a way that makes the chief judge think this would be good for the court as a whole to talk over. So we're constantly having those conversations as a formal matter, just in terms of evaluating what cases should be heard. But informally, you talk to your colleagues. It's just like, oh, what do you think about this? So this is a long way of saying there is no set number. I think that we all kind of have informal conversations, but at a certain point in time, I think that obviously we'll revisit issues when it becomes the point where it's appropriate. I think that
momentum can matter.
Yeah, momentum can, though I will also say that they're different. It's a different push me, pull you, because you have something like Hallmark that came out, right after the Third Circuit, I believe, where the court restated we are still, based on our analysis of the tax context and structure of the statute, we think that that this is a jurisdictional provision. And so it's one of those things where at what point in time do you revisit the revisiting? I don't know. That's something where it's a classic discussion amongst colleagues at conference of, hey, I've got a case and I think that we should take it up. And if enough people think, let's take it up, even if the chief judge doesn't necessarily think that the time's right, then we'll take it up and we'll talk about it and we'll figure out what to do.
Another major trend that's been going on have been the easement and micro-captive cases. Any movement, any change in the trend of how those cases are playing out or the stream of them coming in?
Well, I think that the stream has lessened just on the level of most of these transactions seem to be in the 2016 to 2018 range. So at least from what I've seen anecdotally, it seems like there are fewer cases outside of that range. So I don't know what that means, if that's just a blip or, like so many data points. Maybe it looks this way for a second and then it'll change. But we continue to do a lot of work on conservation, easement, and microcaptives. Obviously, we don't necessarily drive the train because we are ready for trial when the parties tell us they are ready for trial. And as Judge Gustafson once told me, if the parties don't have a dispute, I don't have something to resolve. And so I try to keep that in mind, and I think many of our colleagues do. So when the parties are still talking, when they still want to discuss settlement, if they're in the appeals office, all of these things, we're willing to give them their time, and then when they're ready for trial, we're ready to schedule them. So that's the process that we're following, and we're going to continue to follow. I will say that obviously a number of these cases have been argued recently, and they're often in the Southeast, so that's 11th Circuit country. So I do wonder if we're going to get some guidance from the 11th Circuit, and of course, that's I think from my time as a litigant, once you get some more data points, you have a better sense of what to do. So my view of this is I'm not sure if it's lessened or where we are in the audit or examination cycle of these. We continue to do our work just as soon as the parties will let us on them, and we'll just have to see what happens with different developments in the 11th Circuit or the Supreme Court or any other circuits, and see if that changes the posture between the parties.
Support for this podcast is provided by the University of California Irvine School of Law Graduate Tax Program. This preeminent and innovative program prepares students to practice tax law at the highest level in the U.S. and abroad. Featuring a low student-to-faculty ratio, cutting-edge technology instruction, and dedicated career support, UC Irvine's graduate tax program helps prepare students for a future in tax law. Program graduates are placed in top tax-related industries practicing law in many major U.S. cities. Applications are open now. For more information and to apply to this highly selective program, visit law.uci.edu/gradtax. That's law.uci.edu/gradtax.
Speaking of the parties driving the train, one of the parties before you has just gone through a rather, shall we say, hectic year. All of the changes at the IRS, the 25% headcount loss, so many different commissioners in 25, IRA funding, shutdowns. Have you started to see an effect from the IRS's turmoil on the litigation that you're seeing either coming in or in process?
I will say, as a trial court judge, I have seen only outstanding lawyers by the IRS. It's the same quality of lawyers that I've seen all along. And whatever's going on behind the scenes, I haven't picked up anything that makes me think that the government isn't being ably represented at all times in front of the tax court. And that's what we want. So the types of cases, I'm really not equipped to go into that. But what I would say is the advocacy has remained consistent with everything that I've seen over the last 8 years.
No notice change in continuance requests or time to get cases ready?
Well, obviously, with the government shutdown, as is in every government shutdown, there are continuance requests. But no, I mean, the parties, it's tough because, sometimes it's who is the wizard? Is it the judge behind the veil that's the wizard? I like to think that the parties are actually the wizard because I don't have any particular insights into them. But what I can tell you is it does not feel like I'm seeing much of a difference between the parties in terms of the litigation that I've experienced over the last 8 years. So kudos to both the attorneys for the IRS and the kudos to the attorneys who are opposing the IRS because the standard of work and the professionalism is truly wonderful, and that's one of the joys of the tax court. I remember as a young attorney in Chicago doing a DEP, and an old Chicago attorney objected to every single question I asked just because I'm the young guy and he's going to give the young guy a lot of junk. And I mean, you see the lawyers in the tax court, and there are so many people who look out for each other. And I know people who leave, one area of the law or leave government practice. They're welcomed by the tax court bar. It does not feel very competitive in the tax court bar, collegial, both in terms of the government attorneys as well as the private practitioners. So it's really heartening, and I think that culture has been built by a lot of great people for a long time, and so we're really lucky to inherit that culture from the people who have come before us.
Any other litigation trends you're seeing? I have to imagine some of the pandemic sorts of credits might start showing up, even though most of the employment retention credit cases, they're mostly in refund position, but I imagine some might show up.
Really, I haven't seen any noticeable trends aside from the microcaptive and conservation easement cases, which of course are well documented at this point in time. But I think that looking at our last congressional budget justification, we're still at about 91% of our cases being just regular plain Jane deficiency cases of some stripe. So, in terms of topics, you always hesitate because I might be seeing something in Albuquerque, and then somebody in Chicago sees something different, and that's the tough position you're in with a nationwide court, because just as I was talking earlier, conservation easements seemed largely in the Southeast. If I had a trial sitting where I was in Seattle and San Francisco, I'd probably say, oh, yes, there are no conservation easements. There is no flood. What are people talking about? But if I'm sitting in Atlanta, as I was for a while, I'm thinking there are only conservation easements. No one did anything else in 2017 except get involved in a conservation easement transaction. That is the core of our work. So it's one of those things where I think that it's a little bit more helpful to just broaden out like the jurisdictions that we have: whistleblower, lien levy, deficiency. Where are we? We're still heavy in the deficiency, as we always have been, and then lien levy after that.
So you've had your new case management system, Dawson, in place for about 5 or so years. It's not really all that new anymore. How has it been working out, and is anybody pining away for the old one?
I don't think so. I mean, internally, I will say, our dear beloved Blackstone did a good job of getting, some basic information that we needed. But Dawson has been a game changer for the court. And what's been really cool for us is just seeing people pick it up. So I think last year we're up to about 70% of our petitions being digitally filed. I was anecdotally on a call with some taxpayers for an upcoming trial session, and it was a pro se person representing herself. And I said, you can bring these documents to the trial session, and we'll make sure that anything that you want, if it's admitted to evidence or you want to admit it to evidence, we'll make sure that it gets uploaded. And she's like, do I have to? I'd just prefer to put it on Dawson and just do the digital upload. And I said, yes, please. That would be wonderful. Thank you so much. And so I think that it's really a testament to the Dawson team, Judge Book, who really shepherded it from its very early stages. But we've got amazing people who run it: Chris Hawley, Tennille, Mike Marcotte, Mike McVicker, our deputy clerk of court, for all of our information technology. I mean, they're always working and always thinking about how to make this so that the judges have information presented in a way that they can do their job and complete the mission most effectively. But on the flip side, that the litigants have a good user experience so that they can get the information or they can upload things. And I think that as a person who has not had to tangle with CMECF in a number of years, and who every now and again hears a horror story or two from my colleagues back in that world, I'm very happy with what we're doing on Dawson and the commitment of the court to keep on refining, keep on making it better. I mean, again, the hard thing for us is that we are a court where we have a lot of personal data. And so that is something where we take it very seriously. I know that sometimes, frustratingly so, for some of us on the other side of the podcast mic.
We'll get to that in a moment.
Oh, good. Yes. But we take that seriously to try to make sure that the public has access as much as we can without compromising our commitment to safeguard some of that data.
Before we get to access to the documents in just a moment, any notable, especially public-facing Dawson updates in the works?
I don't think so right this second. And I'm kind of racking my brain. At the end of last year, we had a number of things that were percolating, and we've been trying to make this a more user-friendly experience, both in Dawson and in the website itself. There was a website redesign which rolled out right as the government shutdown was kind of ending, that we had been working on for many, many months. And the name of the game was really trying to make this as accessible for folks who are trying to file something in the court as possible, or trying to get information from the court. I mean, it's really impressive because, I grew up with the classic thing where the three little bars and you're trying to figure out where can I find that information? And now the website has been totally redesigned to make it very easy. What do you want to do? And go there. And I would also say that Dawson has a lot of the same type of inputs where it's trying to be very accessible, because 70% of our people when they walk through the door aren't represented and aren't necessarily lawyers. So we want to make sure that those people can take advantage of our investment in this area.
As we said, time for access to documents.
Oh, man.
There have been a couple of movements in the last couple of years for which I am grateful, and I'm pretty sure the tax community is grateful, getting post-trial briefs posted and return of requests through email. But the appetite, as you say, is insatiable. We would always like more. Are you working on anything like motion briefs or pretrial memos that might also get posted online, the sorts of things that are arguably much less likely to have bank account numbers, SSNs, that sort of thing?
We're always evaluating this. So we're trying to figure out if the briefs, as you said, was an important step forward for us, because we were able to figure out, okay, we can give this without compromising some personal data. But while an important step forward, it's also a bit of low-hanging fruit. So, there are so many other areas where you think you have something, and then you bring together a number of people because you want to have a number of perspectives, and then it's like, that presents these problems. So we're still thinking about if there are any other areas. We are, actively considering things, but until and unless we can figure out, a way to do this in the same way as briefs, or as you mentioned, kind of the email records where the judge actually can look and say, okay, yeah, these are fine. There's no PII in here, or I'm comfortable with these being released. Then we're kind of just sticking to safety is the name of the game, and I wish that we had perfect redactions. We don't. No offense to our wonderful litigants, but even the most experienced folks miss something, and it's really hard. So I realize that. So we are going to just keep on evaluating things until we find other areas, and then we will let the tax community know if there are other areas that we can give broader public access.
So as we start to wrap up, just let's look more generally to the future. What do you see as the biggest issue the court is likely to face in the next year or so?
I think that the court always has to maintain good training of its judges and its personnel in all sorts of things. We live in a changing world, and I think that we need to keep up to speed just internally of new issues that are popping up in the legal landscape. We want to make sure that the folks who are supporting the mission, whether they be clerks, chambers administrators, or other folks, get the absolute best training that they get for their job. So that is something that I really feel very strongly about. And luckily, we have the wonderful Judge Weiler, who is leading with Judge Siegel our efforts on internal trainings. But, just keeping abreast of different developments. Oh, we're seeing this a lot in this case or that case. And then bringing people together and just talking over what's happening in this area of the law to make sure that, again, going back to customer service, we can serve the public just as well as we can by understanding their arguments, or maybe it's a new technology, understanding the new technology, or if I'm a chambers administrator, understanding, Dawson allows me to do this or that. So really, the court believes in investment, and some of that investment then needs nurturing. And so I want to make sure that my wife is an old ed tech person. So she worked for the Mexican government, and one of the things that drove her craziest was computers in the classroom, and then the computers sit there and they do nothing. The teachers don't want to use them. The students don't know what to do with them. They're just kind of something for a politician to show off. So she was very committed. Instead of spending that money, let's design different solutions that will actually help students understand how to exist in a more digitized world. And I always think about that with the investments that we make. We don't want to make investments just to make investments. We want to make investments that will then allow the judges, the CAs, the clerks, the clerk of court, the operations staff to do their jobs better. So over the next year, I think that that's what we're going to be focused on. And I think that that's going to be a continual thing that we're going to try to focus on. We are the beneficiaries of taxpayer money, and I take that very, very seriously, that we owe the taxpayer a good product in return for the money that they're giving us. So, I think that that's something that I really try to remember on pretty much a daily basis.
With the educational reference, I would imagine generative AI has to be an interesting question, both internal use and I believe you recently had one of your first opinions discussing a litigant's use of generative AI, or should I say misuse?
Yeah, it's one of those topics that's out there in terms of I think that every single person in the country is kind of chit-chatting about it and water cooling it. Obviously, the administrative office has started looking at it very intently. So we follow what the administrative office is doing because they do such good work in many of these areas. So just like anyone else, I think that the judges on the tax court, the people who are the administrative professionals in the tax court, are trying to get their arms around it, because it is a question of trying to see what this technology means for doing the job. And that's the prism where how we look through almost everything. It's what does this mean for us to deliver on getting the best, most accurate reading of Congress's action here and applying it to these folks in front of us. So, it's one of those things where it's here, everybody's talking about it, and so the tax court's no different. The judges are kind of making our way through it, and we'll see where the administrative office goes, and we'll continue those discussions. And we'll see if it pops up in any more opinions. You're always interested when it pops up, whether in our opinions or a trial court opinion or I assume a circuit court opinion before too long if it hasn't already. And so just seeing how different folks go and think about this topic, which quite frankly, it's not many lawyers that have true insights into AI. So, It's something where we do need to think about precisely because we're not experts in this area. And as the landscape changes, we need to better understand it and better enhance our use and of whatever technologies are before us.
Well, thank you again for joining us. It's been a very interesting discussion.
An absolute pleasure as always.
That's it for this week. You can follow me online at TaxStew, that's STEW, and be sure to follow at TaxNotes for all things tax. If you have any comments, questions, or suggestions for a future episode, you can email us at podcast@taxanalyst.org. And as always, if you like what we're doing here, please leave a rating or review wherever you download this podcast. We'll be back next week with another episode of Tax Notes Talk.
Tax Notes Talk is a production of Tax Notes. You can learn more about us by visiting www.taxnotes.com/podcast. When major media wants the straight story, they turn to Tax Notes. Thank you for listening, and join us again for another edition of Tax Notes Talk. Tax Analysts, Inc. does not provide tax advice or tax preparation services. Nothing in the podcast constitutes legal, accounting, or tax advice. A full disclaimer is included in the transcript.